matter of opinion on the application of refugee and migrant law in Essex from London and Adjei and Secretary of State for the Home Department.
My lords, my lady, I had made submissions at the end of yesterday on the judge's finding as to what was the statutory purpose. We section 3C2. We looked at paragraph 31, and I was about to go on to hostile environment. But before I do that, can I just show you one further paragraph of the judge's ruling on the purpose of section 3C2, which is important, because if you go to paragraph 36, page 108, you'll see that he addressed Mr Malick's submissions about indefinite extensions, and you've seen that by reference to the statutory scheme in section 3C that limits prevents extensions being made once you are on 3C leave.
So it's paragraph 36,
and it's 108.
Yes,
but it's in this paragraph where the judge identifies, having looked at the this is about 4 lines down, having looked at the legislative history, the language of section 3C, he says it's made clear, in my view, and as I have said, that the main purpose of section 3C is to protect and preserve the position of those who have applied to renew their section 3.1 leave to remain, if, as will almost certainly be the case, their application to renew has not been determined when their previous period of section 3.1c leave came to an end. And then he goes on to say it's not the fault of applicants that there's delay. The Parliament has taken the view that fairness requires that, subject to certain conditions, they should continue to enjoy the same rights, services and benefits as they enjoyed during section 3.1 leave up until the point at which their application for extension is finally determined. Section 3C also makes clear that an application to renew limited leave does not lapse, so he recognises that. But what he's found here, we say there is no error of law. It comes from looking at the statutory provisions themselves, the legislative history, that the main purpose of section 3C2 is precisely to protect and preserve the position in respect of what we were focusing on yesterday, which is the legal rights and the attendant benefits and access to services. So my learned friend's submission based on Patel that somehow this is only incidental to section 3C2 is rejected, and properly rejected by the judge. It's the main purpose of that particular statutory provision.
Can I just ask on the facts, if and it may well be I just missed something, and forgive me, you'll tell me immediately if in these cases, are we dealing with any overstayers who have already had an e-visa or equivalent?
In the overall scheme, since the Secretary of State extended e-visas to classes of immigrants, which we've identified are 25% of the categories of people who have limited leave, then those people fall within the category of persons who have 3C leave. When they have 3C leave, have an e-visa. So they are the category that the Secretary of State has extended.
Yes. What
we say should be extended generally in order to show real time, so this is my immigration status.
So people who have an e-visa already, and overstay, will they still have the e-visa, or will they not have the e-visa?
So I see, I understand you. So if they're not in the 3C category, so their leave isn't statutorily extended, but they actually have no current leave, then their e-visa will expire. Yes, so that will be the end of that, and the record on the Home Office file will show that. Sorry. So that's obviously the benefit of.
No, I'm sure I'm misleading myself, and I hope not you. Let's just say so you have an e-visa. Yeah. Because you fall into one of the categories.
Yes.
You serve a notice, and you overstay. You fall into this 3C category.
No, you never overstay. That's the whole point.
You're not an overstay.
Yes, the term overstay.
Okay, all right. So
remain.
That's one of its central purposes, your lawful status that you had previously continues.
Okay,
But
fine.
is
We ignore
your
that.
chip-
But
yeah.
if you serve the notice,
You make an
and you
application to extend your leave.
you move from a category of person who's got a visa
Yes,
into the 3C status.
yes,
Does your e-visa continue?
yes, yes.
All right.
Yes, and that's obviously critical. That's what the Secretary of State
Yes.
is doing
Thank you.
for 25% of the categories. We don't know how many actual people that is. They didn't provide us with that information, but it's a substantial number of people who, when their leave is coming to an end, within 28 days, they should make an application to extend their leave or to vary it.
Yes.
If the application is not determined, and invariably it won't be, because the statistics show, certainly in the category of Ms Adjei, that it's up to 12 to 18 months before the Home Office makes a decision. So during that prolonged period, your e-visa still continues in play.
Fine.
And it allows employers or landlords or the public authorities to access it, to be able to
Yes.
say, yes, okay, you don't have, we understand you have continuing leave. You still have all the rights and entitlements that you've been
So for
provided
those,
for by Section 3C.
so for people who had an e-visa,
Yes,
their position is preserved.
yes, yes,
But for people who didn't have an e-visa,
yep.
your case is what?
Then they have no means of demonstrating to any third party what their current immigration
Yes.
status is.
But they're in the same
Or
position.
demonstrate it
Status.
instantly.
Well,
Yes.
instantly,
Yes.
yes.
But they're in the same
no,
position that
Can
they...
I just make this point, my lord? They themselves, as an individual, have no ability to do that. The employer or the third party can contact the Home Office if they're willing to do so. So that is an important point. It's not within your control.
We
to
do understand
do
that point. Yeah.
Yeah.
So,
But my point, the point I'm putting to you is that they are then in the same position that they've always been in.
No, they're not, because prior to when they were on Section 3 leave, they did have a means of proving their lawful immigration status because they were issued with a biometric document. So although it wasn't an e-visa, it was a physical document that was acceptable proof.
yes, but that would only show that that wouldn't help you when that expired.
Yes, and but
When my lord said the same position as always been, I don't think he meant the same positions they were in when they had a current visa. I think he means the same position before the e-visa was ever invented.
Yes.
Well, before the e-visa was invented, everybody was in that situation.
Yes.
What you had was a physical document. If you were in the categories that you had a physical
Yes.
document that said your leave will continue.
But in that case, that's a good hook to ask something I was going to ask you at some point. Is it your case that the effect that the Secretary of State was in breach of duty from at least the moment that the hostile environment legislation kicked in, by not having a means by which an applicant and third parties could instantly demonstrate that they had 3C status?
I accept what the judge says about the position prior to the implementation of the e-visa scheme. So that's 213 at page 152 to 153.
So sorry, would you just give me the paras?
Yeah, I'm just being. It's right to say we're using e-visa scheme here because that's the scheme that's now in place. But we should be thinking in our heads a digital document.
Yes,
status.
okay, but my question was the scheme, or not the scheme? What was the Secretary of State acting unlawfully by not having an instant online document available from the moment that the hostile environment scheme came in. And I understood you to say, no, he wasn't, because you've accepted the judge's finding that although he could have issued a bit of paper wouldn't have done the trick, because a bit of paper is frozen in time.
Yes. Well.
Right.
Yeah.
But so which paras did you say?
So it's paragraph 213, my lord, 152, but over the page at 153.
Okay, hang on 1 second. Yes, I just want to follow that up. I want to write the answers down first. Hang on.
Sorry.
I think it then follows, at what point does it become unlawful for the Secretary of State not to have such a scheme? It's unlawful now, you say, but at what point does it become unlawful between 2014 and 2024?
Well, that's the purpose in which that's obviously the key reasoning of the judge at paragraph 203 to 204.
So it's
203.
203 to 204, because those are his detailed reasons explaining why. Essentially,
but we'll say them in your own words.
So it's because he was able to say that there was significant, serious hardship for a significant number of people, and that not to provide a digital document was contrary to the statutory purpose.
But that was true in 2014.
Yes, but I'm coming to that. There's a stage, isn't there? Because it's applying the Johnson formula. But the ultimate point is where it gets to is on the question of is there a solution here that the Secretary of State should have taken? The answer is yes, there is a solution.
But when?
When the Secretary of State, since 2021, has had in place a system, a digital system for establishing online status of the person.
Is it your case, therefore?
And just one further step, because you've asked me to, and obviously, at the point at which the Secretary of State extended the digital record, access to the digital record, to other people who have 3C leave within the 25 category.
I don't understand what you're saying.
Okay.
I asked you at what point did it become unlawful, and
Yes.
your answer was when, since 2021, because that was the point at which the Secretary of State introduced a digital online record scheme. I thought that was your answer. If I got that wrong, tell me.
No, that's when the Secretary of State had in place a system to do that.
Okay, hang on. That's when he had in place a system to do that.
Yeah. And more specifically, when the Secretary of State decided to provide access to the digital record.
When was that? I rather assumed that once the scheme was introduced, it was integral to it from the start that third parties should have access to the digital record. But maybe there's a refinement I've missed.
I think that you'll have to. The Secretary of State didn't provide a date, but by the date of the hearing, the Secretary of State's evidence was, as you've seen from Mr Wright, that there was in place a system of a digital record that could be accessed by certain categories of persons.
So you don't know. Okay, but it follows from that, I think, that it was your case that it was unlawful for the Secretary day one, when it introduced that scheme and/or at least made access to it available to everyone. It was unlawful not to do that for all 3C people.
Yes, that is my case. That's what the judge found. Yes.
Yeah, I know, but from our word aside, whether the judge was right.
I understand that. But yes, of course.
But that means it's almost all schemes of this sort are understandably introduced in stages. You have a rollout. I've never heard of any big scheme of this kind where everybody goes live from day one.
Well, your lordship is now your lordship is now giving evidence to me. What the judge had before him was evidence from the Secretary of State, which did not state, and he makes that clear in his judgment, that there were any problems of impracticability or cost that meant that this couldn't be done. So that is the evidential basis and the finding that was not contested. Indeed, you'll see in paragraph 210, that was also on the basis of, it begins at 210, the paragraph, page 151, but if one goes to 152 at the top of that
So it really
page,
comes down to the burden.
if I just conclude this, is that it's not only that there was no evidence before me, there was no submission made on behalf of the Secretary of State to the effect that there are reasons of impracticability or expense as to why the Secretary of State would not be able to provide those on Section 3C leave with digital proof of their status.
I'm aware of that paragraph. Just give me the reference.
It's paragraph 210, 152.
Towards the end of it.
So does it really come down to this? It's a question of burden. Is it for you to show that he could and should have done it earlier? Or is it for him to show that he couldn't?
Applying the approach in Johnson, when it comes to the question of is there a solution available, that's a question the court asked. There was a solution available. The Secretary of State did not say that it was either impracticable or too expensive. And so, therefore, that was the evidence. It doesn't matter who the burden is upon, because the Secretary of State accepted in evidence and submission that there was no practical or cost problem for doing it.
Well, aren't you overstating it? I thought the judge said there was no evidence or submission, which is different from saying he accepted that there were no difficulties.
Well, the judge had material before him from Mr. Wright. You've seen paragraph 13. And his evidence, on that basis, not only did he conclude there was no evidence that it couldn't be done, and obviously he knew it could be done because it was being done for a group of people.
Well, he knew it was being done for a group of people. It doesn't follow it could be done for everyone.
But in terms of that's a different question. What was the evidence? It was actually being done already. Yeah. So it's not even like Johnson, where on the face of it, there was it was going to have to move from an automated scheme to a manual scheme, or invent something that would have allowed the DWP to make an adjustment to their computer system. In Johnson, the system didn't actually currently exist at the time. That's different from our case, where it did. That's an important difference, because we are asking less of the public authority than the court was asking of Johnson. And so and it's not simply about the evidence, but you have to take account of what were the submissions below by on behalf of the Secretary of State. No submissions were made. So that was the position below. This judge could not have spent more time and care in this judgment. That is a key part of his reasoning, and that is to be taken as it reads at face value, because that's correct.
I've got your answer, and that's very clear.
Thank you. I suppose I would only just ask, if we're looking at it as a matter of generality, once you have identified very significant hardship, which the Secretary of State did not accept in Mr. Wright's evidence, you've seen those two paragraphs, where he says on page 4, paragraphs 10 and 11, he did not believe there would be no prejudice or any real risk that people would be treated as unlawfully. So that was the Secretary of State's case. The overwhelming evidence that was not challenged was precisely to the contrary. So in those circumstances, where there is evidence of significant harm, to which the Secretary of State was on notice, because reports have been provided to her over time, then we do say, at least in terms of justification, there is a burden on the Secretary of State. But
Hannah, you say justification. When this
not
isn't,
taking
this has
the
never
step.
been presented as a discrimination case.
no, well, explanation for why the step can't be taken obviously is within the control of the public authority. They know what the situation is.
I see that.
So, and as I said, we ultimately go back to whatever the matter of principle, wherever burdens lie, you have very clear findings based on what the evidence was and the submissions below that it could be done.
Can I just ask a question about Johnson?
Yes.
Ms Harrison, please. You rely on Johnson as a sort of analogy, but what the court did in Johnson was to look at delegated legislation in effect and say the Secretary of State should have fine-tuned this delegated legislation in a particular way, and it was irrational to do that. It's rather different, isn't it, than making practical arrangements to do something.
Well, my lady, can I just say this, is that we didn't rely on Johnson by way of analogy as such
Right.
to the facts. What we did, and the judge recognises this because he says the facts are not the same. They clearly aren't the same. But there are principles that have been identified, not just in the Johnson case, but from the Law Society case, and applied subsequently in this court in Pantellerisco and Salvato. So in paragraph 50 of Lady Rose's judgment sets out a guidance as to how to approach the assessment of the Wednesbury irrationality test. So it was the approach that we invited the court to adopt, accepting, of course, that this was a very different case, as the judge himself recognised. He says that in a number of places. Sorry, I'm grateful for this. This is at 214 is an example of that. He wasn't doing what Mr Justice Cavanagh had done in Pantellerisco or had been sought to do in Salvato, which is to say, this is what happened in Johnson. We're in the same position, therefore you should have the same outcome. They were fundamentally different cases, but the key distinguishing feature in Pantellerisco, which your Lordship, Lord Justice Underhill identified, I think it's at paragraph 77, is that what was being attacked in Pantellerisco was central to the scheme. And therefore, it couldn't simply be said that we're making an adjustment. Here, for the reasons that we've sought to develop, first under section 3.6, and as I was going to do in terms of the hostile environment, it is central to the immigration scheme now in place, whether a person has lawful or unlawful immigration status. I mean, in a way, it's trite to say that. Of course, that's what an immigration system does. But what the hostile environment measures do is to make that relevant in a whole panoply of different ways in which an individual interrelates with society. So, as the judge found, we can go and look at his findings on the hostile environment. What is at the heart of that system is distinguishing between those who are here lawfully and with lawful immigration status and those who are not.
Well, it's absolutely up to you. You know what are the points you need to cover, but
Yes.
all of us are pretty familiar with how the hostile environment works,
I'm grateful for that.
and the judge, as you say, makes very good findings about it.
Yeah.
You needn't worry that we don't understand how serious it is for those who are not in a position to demonstrate their status.
Oh, I'm grateful, but perhaps then it's what I was going to address is because it is specifically attacked by Mr. Malik in paragraph 204, which is a key paragraph in the judgment, about the underlying purpose of the legislative framework. And he says that the judge was wrong about that. It's not about documenting lawful status. And we say that when one looks at the statutory schemes, the judge analyses those, but where a statutory scheme identifies those who are disqualified, for example, from work, because that's the language that's used, and creates civil penalties, £60,000 up to £60,000 if you employ somebody who's disqualified, or you commit a criminal offence if you're an employer, up to 5 years imprisonment. If you have a scheme that is based on disqualification because of your immigration status, then the ability to demonstrate your immigration status, to show that you are here legally, not illegally, with the right to work or to rent, etc., then that is obviously at the heart of the system, as the judge said. How could it not be? You have to have a means of demonstrating your lawful status if it's determinative of whether you can do basic things that are part, as Lord Wilson said, of normal life. Go to work, rent a place, access benefits if you need them, drive. If you're a female who needs a victim of domestic violence and you need access to a refuge, even that is dependent on your immigration status. And we had evidence to demonstrate that women were being turned away because they couldn't show their lawful entitlement to access. I accept fully what your lordship says about taking on board the evidence that the judges carefully addressed in those extensive paragraphs. But in doing so, and in accepting his analysis of both the nature of the statutory provisions, their purpose, we do say that there is no basis, if you've done that as he did, and that's the foundation of 204, to conclude anything other than the underlying purpose of the legislative framework is that there should be a hostile and unwelcoming environment for those who are unlawfully present and so who are undocumented. The corollary of this is those who are lawfully here should not face the hostile environment. That can only happen if they are documented. So we say that the suggestion...
Sorry, is that a quote?
I was quoting from 204, my lord.
204, yeah. Thank you very much.
My learned friend takes issue with saying that there's something about the hostile environment or his definition of the hostile environment does not include anything about documentation. But we say it's plain, and particularly when you look at the evidence, what happens if you don't have a document to prove your lawful status? You end up with being tipped inadvertently into the measures that deny you legal rights and entitlements that you have by virtue of Section 3C. So, if your lordships and my lady are with me on that, the judge has properly concluded what the purpose is of the hostile environment and its corollary. It is evident, we say, that he was correct to link it to documentation. That's what the statute does, that's what the policy does. But the problem for those on 3C leave is that they don't have their status documented, and they're in a unique category.
It does cast you back to the difficulty that until the e-visa, using that as a shorthand, was invented, this problem was inherent in the system.
Well, my lord, can I put it this way? For the purposes of this case, I don't need to argue that the system was unlawful at an earlier point. We didn't seek permission to cross-appeal on the finding that about physical documents, because we don't need to. So it's not a concession that we make that it was lawful previously. And we can't argue that case now. What obviously we are arguing is the case on which we succeeded.
Yeah. Okay, well, fair enough. I just wanted... You're right, I shouldn't have gone back to that.
To that extent, it must be of reassurance to the court. As the judge quite clearly said, he wasn't declaring the system going back to 2014 unlawful, he was saying from this point, at the point of his judgment, on the basis of the evidence that I have heard and the submissions that I've heard, it's not lawful now.
Could
So
I
that
just
limits
ask one
the
other
impact.
question, really, which is related? What is the effect of the declaration that the judge made in terms of what the Secretary of State should now do? It's, as you know, very unusual for the court in judicial review proceedings to order the Secretary of State to do anything in particular. They make a declaration that what he is doing or is failing to do is unlawful, and leave it to him to put it right. But in this case, what are the practical implications of the declaration? Put it in another way, but suppose there had been no stay granted. What should the Secretary of State have done if you win this appeal or successfully resist this appeal? What should he do once our judgment is handed down?
Well, on the basis of the evidence and submissions before the court, the judge anticipated, if you see at paragraph 204, page 150, that there was a simple and straightforward way of giving them documentary proof which will enable them to provide instant evidence of their status. So, on the basis of the material, the judge anticipated that it would mean to do what you've done for 25 categories to all the other categories.
Yes, I see. So it's simply a question you should implement forthwith
Well,
a rollout of the e-visa scheme to all other categories.
well,
What if he then, is he too late for him then to come back and say, sorry, can't do it. It'll take 2 years because it's very resource intensive.
in my respectful submission, you're asking me what the Secretary of State should have done. The judge identified irrationality in the approach that the Secretary of State was taking. So he would take his cue, first and foremost, from what the Secretary of State said. The Secretary of State did not oppose the declaration. That's at page 412, paragraph 3. So it ought to have been the Secretary of State thinking about relief and what should happen. We've gone there with a particular purpose, and that's been achieved. It's not for us then now to devise for the judge how that ought to be done. The Secretary of State did not say to the judge, please do not make the declaration now because we need time in order to think about this and to see what we need some time. That would have been a solution that Mr Malik could have proposed. There are situations where that can occur.
What was the citation for the Secretary of State did not oppose the declaration? I can't find it on page 412. Maybe I'm just looking in the wrong place.
My lord, it's 410 of the core bundle, paragraph 3.
410.
So it's for the Secretary of State to address the consequences of the judgment. But in that respect, my lord, of course, there are situations where this kind of situation arises. So I'm thinking of the detained fast track.
Yes, I'm sorry, I hadn't looked at this document before. I'd looked at the order, but I hadn't realised it was followed by reasons. So we do actually have
His explanation.
We do actually have mandatory. Can I just read the section on mandatory order?
Paragraph 6 is relevant.
We asked for a mandatory order and he said no.
Yes, right. Sorry, but I didn't know any of this. So,
Sorry, my lord, yeah.
And because this was left out of the original bundle, and I'm afraid I
Sorry, my lord, yes.
finally tracked
of
it
course,
down.
yeah.
I didn't realise what it consisted of.
Yeah, and
Just let me read it first, and then you can make submissions. yes, I see. So he turned down the mandatory order on reasons specific to the facts of
Yes.
Ms Adjei's case.
And it was only in respect of her individual case that we sought a mandatory order.
Yes.
The Secretary of State did not oppose the declaration you
No, I've seen that.
And he
Yep.
dealt
Okay.
with the stay at 414, paragraph 28, by citing authority.
Hang on 1 second.
It's paragraph 28, my lord, 414. And
Well, yes, but obviously a important part of his thinking was that, as he put it, defendant intends, regardless of the outcome, to provide e-visas to those with 3C leave by the end of 2024.
yeah,
So he thought, well, this is all happening anyway. This order was being made.
yes. And
We don't know because we only have the evidence that was available at the time. We don't know whether that has in fact happened.
well, we don't, but
And anyway, we don't need to know. I'm just trying to
see. But
just trying to identify.
But what you can see from that discussion, from those reasons, is that clearly when the public authority gets a judgment like this, it immediately needs to decide what it ought to do. And
Yep.
in this case, as you've seen, there was no objection to the declaration.
No, okay. Well, you're repeating. Yeah, okay.
But can I also make this point as well, is that although, as you've seen in Mr Wright's witness statement, reference was made to the existing rollout of the e-visa scheme to those, including those who would have 3C leave, that was relied on by the Secretary of State as indicating to the judge, well, you know, it's all in hand.
Yeah.
You don't need to do anything about it. So you can't have it both ways. You can't come to court to say, well, there is a scheme in place, so judge doesn't need to intervene. The Secretary of State is going to deal with this. But then come along subsequently, once the judge has said, well, what you're doing is not lawful at this point, and say, well, we want to, the scheme that we've implemented means we can't do what you've said we should do. I mean, that's essentially what's happening here. The Secretary of State seeking to have their cake and eat it in this case. We have got it all in hand, don't worry. But now apparently relying upon the fact that it was in hand as justification for suggesting that the judge has acted unlawfully in his reasoning and is in his conclusions. And we say the court shouldn't entertain that. It's very important at this level that one respects the way the case was put below, both in terms of evidence and submissions, because otherwise this is what's prohibited in the authorities. That was Mr Malik's dry run at the case, and he's re-argued the whole case all over again, which is essentially what he's done, even though in every way in which he's advanced the arguments to this court, he has advanced them below, and we were rejected.
Well, that's what an appeal is about.
Yeah, but
You can't complain that he's rerunning the arguments below that were rejected. That's just he thinks the judge was wrong to reject them.
Arguments that but they have been specifically addressed, and the critical issue that is now obviously concerning the court as to, well, what's the effect of this judgment? One has to deal with this case on the basis that the judge had it before him, as I've showed you 2000.
No, well, I've absolutely got that point. Yep.
I'm grateful. So that's why we say that if the Secretary of State could identify a period of time, then I'm sure the judge would have entertained it. But what he was faced with when he gave his judgment in June was that this was all going to be done probably by December. He thought there couldn't be slippage, so he was still going to rule. because there was the indication, the suggestion that it might be academic, but that could have been what the Secretary of State said, and one can't now.
You see, there's no pecuniary claim running on any of this.
Pecuniary claim.
No one saying
Damages.
No
Damages.
damages claim. No, there isn't a damages claim, but
Well, there couldn't be, because it's a purely public law claim.
we didn't run it. We haven't run a human rights claim.
Yeah.
That's correct. Obviously, there was some pecuniary loss because
No, quite.
this is a.
Okay. Well, thank you. I understand this is not central to the case, but you appreciate for us that it's an odd situation, and it's that's been very helpful background. But I won't lose sight of the fact that ultimately we got to start with the judge was right in making the orders that he did at the time that he made them.
And
Right.
the only
Where
one
do we
other
go from
further
here?
observation that I would make, just to show that this is not unique, and I was going to give it as a good example. Your Lordships will be aware that in 2015, this court ruled the detained fast-track rules that govern all asylum appeals to be unlawful and ultra vires, and that obviously had significant impact, and that took effect immediately, and the rules had to be changed. And so that is sometimes what happens. Obviously, in Mrs. Johnson's case, the court made its ruling on irrationality, and the Department of Work and Pensions had to take a step, it seems to me a more significant step than the one that is required here, because it did require the creation of an automated system.
Well, I'm not
in
sure
order
it did
to
actually.
accommodate
No,
that.
in fact, my clear recollection in Johnson, you'll tell me if I remembered it wrong, is that in the short term they had to go on doing it manually, which
Well, they had to do it manually,
which they said was very troublesome. But
Yes, but they could do it.
But they
you're right.
could do it. Yeah.
Yeah, so it caused, and what was relied on was automation was a central part of the whole scheme, and one can imagine why,
Yeah,
given they were
and
dealing with
certainly
that.
part of our judgment was that not at once, but given the nature of the problem, it would be solvable by automation. So we were not asking them to do it. It couldn't be automated, but they'd have to take their time to do it.
Yes, and
Okay.
here we are, the system is in place, you just need to now apply it. And if you'd have been in that situation for Mrs. Johnson, then obviously there would have been an even more straightforward step, which is just extend it to this category that's been identified to otherwise cause very significant harm. That's exactly the category we are in. So, my Lord, if I can take stock of where I was going to go in light of what your Lordship has said about the paragraphs of the judgment which are detailed and dealing with the hostile environment. I think a submission that I do have to make, because my learned friend has said that it's for the Secretary of State to make the assessment about the nature of the hardship and whether or not anything needs to be done. So I was going to show you because what the judge does is twofold in those lengthy paragraphs, beginning at 48. So we just go to that at 111. Penalties for employing a person who is not lawfully present in the UK. So that's the heading under which the court went through all of the hostile environment measures. But what the judge also did at the same time, and I'll take this speedily because you're taking on board, is he identified the provision of the hostile environment and what the statutory provisions did. And he then made a number of findings about that.
So where are you? Which passage are you
It's
taking?
48, my Lord. If I can ask
48 onwards. Yeah.
yeah,
Okay.
so, yeah. He deals with work at 48 to 66, and I'm just focused on that for one moment because that's of particular relevance to my client, and I want to just show you how the checking service worked in reality for her.
Well,
That's
absolutely.
also
Do if you want to. I don't know how much time you want to spend on other parts of the case.
yeah. Well, if I
Just be aware that if you are short of time,
Yes.
Just ramming home the nails on a point that's pretty clear may not be the best use of it. But up to you entirely.
Well, I think it's
Up to you entirely.
what I want to submit then is when one looks at all of those paragraphs and they go up to up to 90. Those findings that the judge makes about the consequences of not being able to demonstrate your lawful status and the hardship that involves, that's the basis for his conclusion that it's significant hardship and can be grave hardship. The Secretary of State says, well, that's a matter for the Secretary of State, to which only irrationality can arise. And my respectful submission is this, is first of all, that was unchallenged evidence. The there was no contrary evidence on to say that these disadvantages wouldn't occur. The Secretary of State accepted not only the truth of the content of the extensive evidence that we had, but also accepted that there were difficulties in light of that evidence. And so I'd ask you to reject that submission that was made, that the judge took a wrong approach to the evidence, because it's clear that he made detailed findings on essentially unchallenged evidence. And that goes critically to a question of the gravity and the nature of the hardship that was in play, where there was a clear difference with the Secretary of State's witness saying that they didn't accept prejudice and they didn't accept real risk of being treated as if unlawful.
Well, they're not necessarily inconsistent, because the evidence was that by and large the two different checking systems worked within the timescales, without knowing how many people make use of these checking systems, without knowing how many individuals your evidence covered, the things aren't necessarily inconsistent, because the system can be working generally okay, but nevertheless not work in individual cases or not work in several cases. And when it doesn't work, it can cause hardship.
Yes, but the critical finding of the judge is that it would cause hardship in a significant number of cases.
But what does significant mean?
Yeah.
Well,
I mean, sorry, that's what I was trying to get at. Significant as opposed to, you know.
well, if I give you the references on what he did find about that, there are a number of them. And if you go to paragraph 56, that's on page 112. And he says the effect of the provisions that I've just described and the compliant environment regime generally is that employers are not normally not willing to employ or to continue to employ. There's a right to live and work. It is in doubt unless they are able to obtain proof that they're entitled to work. So he recognised the kind of chilling effect or deterrent effect of a person having to establish their status and the concerns. What he said about, specifically about the policy is the checking services at the end. The aim of the Home Office is to provide a response to an ESC check within 5 working days. And the Home Office believes that this timescale is ordinarily met, although it does not monitor the times taken. The evidence on behalf of claimants is that sometimes the process can take considerably longer. It's difficult to obtain reliable data because employers do not necessarily inform employees or prospective employees when they have commenced the check. And he goes on then to say how even if you've got a check, even if you've got a positive confirmation, it only lasts for a limited period of time, and that's not coexistent with how long it might be in order to
yes, I mean, but it's still the same problem, isn't it? It's perfectly obvious that there will be some cases in which the time taken to make the check means that the job won't be offered, even if it's done within 5 days, or A40 or I, if it takes longer.
Yeah, exactly.
But how many cases no way of knowing. Data, sometimes the process takes longer, difficult to obtain reliable data. It is, and it's no criticism of anyone, but that's the fact.
Well, the fact that's the fact because the Secretary of State does chooses not to monitor and to obtain that data.
But even if the Secretary of State did monitor, they wouldn't know how many cases employers had said, it's a faff to have to do this, I've got 2 candidates, so I will, although this one looks marginally better, I can't check their immigration status, so I'll have the other one. No data would ever show you that.
Agreed. So that's one category, and the judge was correct to say there's a real it's likely that employers or landlords will be deterred from selecting the person with the unclear immigration status. So that is a group. Then there's the question of the scheme that's been set up. Does it operate within 5 days? We had extensive evidence, including the individual case, to show that it wasn't operating within the time frame.
Well, I think your evidence was, but if I've misunderstood it, you must show us the findings.
Yeah.
I'm meaning this not in any pejorative sense. It was anecdotal. It's bound to be anecdotal because it's very difficult. There weren't any controlled surveys, were there? The RAMFEL were able to say, because they deal with a lot of these people, this is something they see happening often.
Yeah.
And they gave some more individual cases.
Yes.
And we got Mrs Adjei's case. But
well,
if there are, proper figures, you must remind me of them. But I didn't get, that wasn't my reading of the judge's findings.
Well,
I haven't read the underlying evidence because we have such full findings.
Yes, well, in those circumstances, there was evidence from RAMFEL that it was that there were problems in significant numbers of the cases that they were dealing with. That was.
Yes, I'm sure, and nobody's doubting that. But it's quantification that is the problem.
Yeah. Well,
and Mr Malik says when quantification is a problem, it must be for the Secretary of State to make the judgment.
It's paragraph 82 was the RAMFEL's research that was referred to at page 118.
Yes. Thank you.
And without, I can give you.
Let me just remind myself of this is this, as it were, the high water mark of the quantifiable evidence?
Yes, I think it is, definitely. Yeah. From RAMFEL's point of view, that was what they were able to identify.
Okay, well let me just remind myself exactly what it says. No, well, thank you. That's characteristically clearly set out by the judge.
And that's in the supplement. The report is in the supplementary bundle, isn't it?
Yeah.
Yeah, the full report is in the supplementary bundle at 50. But what's also important is that the information that RAMFEL were able to give was consistent with what a number of other organisations working in the field were able to give, because you'll see if you look in the supplementary bundle, just to look at the list, the index, so we can see there was evidence. This is from a woman called Chrissy-Ann Jarrett, from an organisation called We Belong, which is at 141, and that's an organisation that specifically looks at the situation of young people, and they have written a number of reports. There have been 3 that identified this problem for the category of people that they assist. The Joint Council for the Welfare of Immigrants had a scheme with Unison, an advice scheme, and they were also able to say that formed a significant proportion of the numbers of people who were accessing that scheme. Perhaps it's worth just looking at that. It begins at 159. and there's the information that they were able to give about that call, that scheme that we're offering is at 38. And so they were able to identify the numbers of calls that they had about people who were having difficulties accessing employment rights through reliance on the scheme, and they were able to say that it was 405 calls out of 849 that they had. I don't know if this would be of assistance, but what I have prepared, and then I won't need to take you to any further evidence, but with this in mind, I can give you the references to the material that explained the broader nature of the problems that each of the witnesses were explaining, and then that will obviously save time from doing that now.
Has Mr Mallet seen this?
No, I didn't know whether it was... I can give him a copy.
He hasn't seen it in advance?
No, I wasn't sure
Normally,
whether
if
I'd
you're
need it, because I thought we'd go...
Well, you thought you might need it, and therefore...
Yeah, so I should have done. I apologise.
Okay, well,
but
don't worry.
it is only by reference to the document. So if I could just hand that up, and then rather than doing this task
Okay,
now,
well, we'll look at it.
you can look at it because it gives you those references.
We'll look at it de bene essay at the moment.
Thank you.
It's just references to the evidence.
Yes, so it's
I mean, I have to say, as I think I said yesterday, I found the judge's account of the evidence unusually full and clear.
yeah.
And in preparation for the case, I felt confident going by his findings. So I'm not terribly keen to get into the weeds of the evidence where the findings are so full and comprehensive.
Well, in those circumstances, my lord, then we went down this path because I think you were questioning the foundation of his judgment on hardship and the extent of the hardship. It was based upon the material.
Yeah.
Key material that he identified was by way of example, but that example was illustrative of general problems in the system.
To be fair to my lord, I think the point he was making is it's difficult to get a handle on what significant means in the context, whereas the judge recorded in paragraph 37 of the judgment, there were 370,000 people on Section 3C leave in 2019.
Yeah.
And I think that's all my lord's getting at.
Well, ultimately he came to a conclusion that there was a sufficient number of people who were suffering hardship in circumstances where the legislative scheme was such that they should not have been suffering hardship because they have lawful rights to be in the UK. That was the factual foundation that he made. You've recognised that he did a very careful job on that. And what I could, and the contrast between that is that there was also plenty of other material that found the basis of that conclusion that I've given you the references to. But
Ms Harrison, if I say so, this illustrates the dangers of island hopping, which we've been warned about so many times in this court, when we're asked to dip into the evidence and go beyond the findings.
Exactly.
The findings are there. The judge was seems to be very careful about how he expressed the findings.
That would definitely be the proposition that I sought to make at the outset.
For my part, I think it would be dangerous to go dipping into the evidence in the way that you haven't invited us to, which you've trailed to coat with the...
You'll accept them as on the basis of what he said, then I don't need to do that, and I wouldn't ask you to do that unnecessarily. But ultimately, if I could just take you back to his judgment at paragraph 204 on page 150, because he does make an important finding on the basis of that, which is about 7 lines up from the bottom. As things stand, the failures to provide them with documentary proof means that those on Section 3C leave, unless they already have an e-visa, do not in practice have the protections that Section 3C guarantees for them.
Sorry, I was just making a note. We're 204. Whereabouts in the paragraph?
It's about 2/3 down, and it's the sentence begins as things stand.
Yes, thank you.
And again, you may not need to go to it, but in fact, that was also the finding of the Windrush review, that the mitigating circumstances were wholly inadequate to protect that category of
Well,
persons.
the Windrush
being
review
identified.
wasn't primarily about people with Section 3C leave, was it? It was about
No, it
it was about problems of not being documented generally.
Exactly, but obviously we're in that category. We're a different category, but the problem that was identified is if even for people who were British citizens, if they do not have documentary proof, then they fell foul of not.
I'm
hostile
obviously very familiar with the Windrush problems, but I don't. They don't form a significant part of the judge's judgments, do they?
He made reference to it, but and I don't need to go to it, but I'm just indicating to you.
I mean, one can easily
that there
see
was
how
that
people
material.
with the characteristic Windrush profile had problems. If anything, I'd have thought their problems were more acute because at least people on Section C3 leave are in the system. If you go to the employer and they ring up the Home Office and they're prepared to do that, they will get a reliable answer. The Windrush problem was much more profound. These people were never documented at all.
Well,
I'm just not sure it's a help, except in the most general sense that it shows the problems of not having documents. It's rather a distraction.
Well, the mitigations that were in place to seek to demonstrate your status didn't benefit those people either. And the key finding that has been this judge also makes here is that that in practice they do not have the protections that Section 3C guarantees for them.
So would it be fair to say that, in effect, what the judge has decided is that the Secretary of State is under an implied duty to exercise the ancillary administrative powers so as to reduce any risk of detriment arising from the inability to show instantly what your status is?
No, the judge has found that the absence of any of digital proof of status means that a significant number of people will be exposed to the hostile environment when they're not supposed to be.
But sorry, you're misunderstanding my question. It's probably my fault. I'm asking what the effect of the judge's decision is, and it seems to me when one reads that sentence to which you've drawn our attention, that the effect of the judge's decision is that the Secretary of State is under an implied duty to exercise those ancillary powers so as to reduce any risk of detriment which comes from your inability to show your status instantly. Because that seems to me to be what he's saying in paragraph 204.
Well, what I read him to be saying is that the system as currently operated does not in practice mean that the protections that Section 3C guarantees them. That's what he's saying.
Yeah, but how many? Clearly, are fine for most people. Even on your evidence, it's a minority of people who suffer problems.
Well,
So the judge, I think what my lady put to you is: are you saying under a duty to use the ancillary powers to provide a system for instant verification if there is any risk of detriment from inability to prove your status? And that is that your position, or is I thought you at one point you were saying no, not any risk, but any significant risk. But maybe you're not saying that either. I'm not sure what you are saying.
I think that risk is not the right way to look at this. The judge has looked at the evidence and has identified that, in fact, the system is not operating in a way to ensure that in practice those with 3C leave and enjoy the protections that they have.
But risk is just a way of saying some people don't.
Yes.
So and what my lady, but I agree with her, are trying to get at is how many people have to be, on your submission, have to be affected before, or what's the test for how many people have to be affected before this duty kicks in. If one person would be at risk out of 370,000, I suspect one would say there was no duty to introduce it. If everybody was, then you would obviously have a powerful case. I don't say necessarily successful case. It was irrational not to introduce it. But the position's somewhere between one and everybody.
Well, I can only say that it has to be a significant number.
Well, that's what I thought you would probably say.
And that's what the judge says. The question of risk arises in the context of the fact that the Secretary of State's case was that there is no real risk. So that's
yes,
how
but that's another way of him saying not enough people are involved.
Well, that's not exactly what was said by Mr. Wright. His no real risk was his position. There isn't any risk. There would be no prejudice and no disadvantage. That was his.
Well, it depends what you mean by no real risk or no. I don't think he's saying. It would be remarkable if he was saying, I cannot see any situation in which any person would ever be affected by this.
Well,
he says the problem isn't serious enough.
And the judge obviously understood that, and on the basis of his assessment of both the nature, the extent of the problem and the gravity of the problem, he thought that was sufficient to mean that the disadvantage did require to be addressed. Yeah. And that's why he went on applied the Johnson elements of it.
Okay, we probably need to move on, don't we?
We do. I just wondered if there was any. No. I think that's as much as I can say on that. That from the judge's point, looking at all of the material, he came to that conclusion, and it's not an irrational conclusion when one looks at the material that he described in his judgment, and in the context of the examples that he gave being representative of a general problem that organisations, legal advisors and advice services were finding from a number of sources. On that basis, we say that my learned friend's submissions on the facts, or the approach to the facts, are to be rejected. And then the question then is whether or not the judge properly applied the legal test, which, as you've seen, was based on the legal reasoning in Johnson, recognising that it wasn't on all fours. We've never suggested it was, but that it was helpful guidance. And if I could just take you to Johnson in the core authorities. Which is at tab 8. We looked at the key paragraphs yesterday, but I think...
I'm sorry, very annoyingly,
could you email Gingy and ask her to see if she can find my core authorities bundle?
Well, I think let's... my Lord's very kindly offering his... I, of all people, ought to remember what's in Johnson, so I'll just make a note and I'll catch up when the bundle is brought.
The references are there.
Yeah, thank you.
So we went, I think, straight to paragraph 50 yesterday, which is
Yeah.
the key paragraph, but it's important to obviously recognise that what the Court of Appeal in Johnson and Lady Justice Rose were referring to was to the earlier judgment of the Divisional Court in the Law Society and the Lord Chancellor case. That was the quote from paragraph 98 was set out in paragraph 48.
Why do you say it's important to recognise that? Because I think that was a divisional court case, wasn't it?
Well, only in that it's a formulation that goes back to that's not just invented. In the
Well, whether it's invented or not, once she said it, it's binding. So that's fine. Yeah.
But yeah. So there we go, and that formulation, which the judge says is a helpful framework
Yes,
and
right.
nothing more. That's essentially how this judge used it. And in identifying disadvantages and deciding whether or not to fine-tune the regulations that were problematic in that case, the court would also look at the disadvantages of adopting the solution, and they would also ask, is it consistent or inconsistent with the nature of the scheme, the universal credit scheme, and then ask whether a proper balance had been struck, such that no reasonable Secretary of State would have struck the balance in the way that the SSWP had done in this case. And as the court is aware, the judgment then went on to apply that helpful framework in identifying the disadvantages and recognising that, as your lordship indicated at paragraph 75 to 78, that what involved there was a change from, or was a departure from the principle of automated assessment, because it would require manual checks at that point. It recognised at 78 that the computer system had been a large investment by the public authority, and at 82 the difficulties of accommodating the change that was proposed, but the court concluded, this is at 82, I cannot accept that the programme cannot be modified to ensure that the computer can recognise that the end date of a particular claimant's assessment period within their salary payday, so that it falls on a non-banking day. So there was a positive step that had to be taken that ran counter to the policy of automatum. And then in failing to enact the problem, enact the solution, the court addressed that at paragraph 84. And one of the questions that was important in that regard was whether or not the department had took into account the problem, and whether it was a deliberate choice. And it's important to note in this case that the way in which the case was advanced until Mr. Malik's oral submissions was that there was no power to do what we had suggested. It was only in oral submissions that Mr. Malik accepted that there was a power, which was the new college implied power. And so that had been the primary defence of the Secretary of State, that there was no power at all to implement the possibility of a digital document for those on 3C leave.
So what?
Well,
I mean, that's a forensic point, isn't it? How does it help us to decide?
Because in terms of whether or not the Secretary of State had addressed the issue, they were on notice. The judge found they were knowledgeable. There was knowledge of the problem, but up until the oral hearing, the answer that had come back is it's not. We don't have a power to do this. So that is important, because that was a mistake. There was a power. In fact, it had been exercised for a significant number of people. That's why there was, after the court, clarification from the Secretary of State as to what the position was, and I'll give you that reference shortly.
Can you just briefly refer us to the passages in the detailed grounds of defence which show that the case was being defended on the basis that the Secretary of State had no power to...
I'll give you those.
or maybe Ms Luke.
Yes, I'm grateful for Malone for mentioning that. I think it is recorded in the judgment at paragraph 107
Thank you.
to 108.
Okay, thank you.
And then just would emphasise in 209 of the Johnson judgment the relevance of the of whether or not what's proposed, what's needed to change would run counter to the scheme of the legislation. You'll see that at 105 and 106. So what the judge says, which is important at 106, is that you would look to whether or not it is running antithetical to one of the underlying purposes of the overall scheme. And the non-banking day was running and contrary to one of the underlying principles of the overall scheme, which was obviously to encourage people to take up employment. And that was an important part of the finding. So, and then she goes on to conclude at 107 that on that basis...
What's the actual submission you're making about Johnson?
Well, I'm showing you the approach, and then I'm going to show you that the judge properly applied it. So perhaps that's all I need to do.
Okay.
But it is important because we say applying that framework and that criteria, as the judge did, we'll go to his judgment, he properly identified the legal principles from Johnson. And in his decision, which begins at 148, at 196, he first finds as a fact, I think I've said significant, a substantial number of those on Section 3C leave suffer real hardship. So his finding is substantial number.
Sorry, which paragraph, Will?
197, my lord. So we're applying...
Can I just say for the record, I've just had a quick look at the judgment. I can't find any statement in 107 to 108 to the effect that you said about the Secretary of State having for the first time advanced in oral submissions, acknowledged in oral submissions that he had a power. There's obviously a debate about the source of the power. It's not quite the same thing. I'm just telling you now.
I'll give you the references.
News. Yeah. Okay. Sorry. Going back to where you were. Yep.
Yes. So,
119.
so in applying that, properly identifying the approach, he's now applying it.
Yep.
He concludes, we say rationally and lawfully, that there are a substantial number of people would suffer real hardship.
Which paragraph is
That's
that?
197.
197. Yep. Thank you.
And 199, he also says that whilst not all of those on Section 3C leave will suffer adverse consequences, it is clear from the claimant's evidence, not challenged by the SSHD, that a significant number will do so.
Yeah.
And then he identifies what he describes as real hardship. And just to emphasise this now, because it's relevant to the Section 55 point, he says it's also inevitable that dependent children will suffer hardship as a consequence. And he says, again, at 200, that his assessment of the consequences of the absence of a means of proof is serious adverse consequences for some people in other respects, for example, seeking healthcare, university places. And in some cases, it will be very severe indeed. And that was obviously based on a number of the examples that were given. He also makes the observation about causing stress and worry for individuals as well. So that is the nature of the extent and gravity of the hardship that he properly identified. At 202, he deals with legislative purpose, which we've considered, and we say that he has properly identified the purpose of section 3C, even if one looks at it in isolation, that's 203. And my learner friend criticises the reference to exactly the same terms, but I think as my Lord Justice Baker identified, that is by reference to benefits or entitlements, so that he's not saying in every respect it's the same, but in the key respect that we're concerned with, where it relates to benefits and entitlements, it's on exactly the same terms. And then at 204, when he then puts the purpose into the in the broader perspective, as he describes it, that's looking at the hostile environment measures. He properly identifies the purpose of that, and as I've indicated, he's right to identify that within this hostile environment scheme, being able to prove and establish your legal entitlement by being documented is key. And that is also not open to challenge as unlawful or an irrational approach. Then is the question that my learned friend focused on in 204, which is the simple and straightforward way of giving them the documentary proof that will enable them to provide instant evidence of their status. And I've given you my submissions on that. That was on the basis of the evidence that he and the submissions that were before him that I've showed you in paragraph 210. He was right to reject the submission based on Patel. It wasn't incidental, it was at the heart of the statutory scheme. And in my respectful submission, the judge was also right to refer to the fact that the situation was meaning that those on section 3C leave were not able to enjoy or have effective legal rights, which is obviously the proposition from the M and Scottish Minister's case. That's precisely what happens here. You have a legal right to be in the UK lawfully and to access services and benefits, but you're not able to effectively do that in a substantial number of cases without being properly documented. And as he says at 208, what was critical for him here was when it came to assess the question of what he described as the most significant point, is it impracticable to do so? And he addresses that in detail at 209 and 210 and comes to a lawful and rational conclusion based on the evidence and the submissions of the Secretary of State that there was no impracticability or expense or cost problem that would mean that you couldn't take that step. And because the scheme was already in operation, it was properly to be described in the language which comes from Johnson as a straightforward step. And so we say 212, where he then summarises his approach, applying that four-stage framework. We say that the reasoning is correct and not open to challenge as unlawful or itself irrational and not wrong. So in that respect, it's important to note that when the judge came to those conclusions, he did so having properly directed himself as to the nature of his function. And if I could just ask you to go back to 147 at paragraph 187. So first of all, he fully recognises that there is a high hurdle to overcome. He recognises that that the approach may vary depending on the context, and that this is a context in which the hurdle will be high. He recognises that this is not a challenge to an exercise of a power or discretion that has been expressly conferred by a specific statutory provision, but is part of a broad package of ancillary and undefined powers in the New College case. So he's cognizant of that fact. And that it was also requiring the Secretary of State to take a positive step. And as he makes that point, and I know that this was a point that concerned my lady in granting permission, so it would be helpful if we could just take up the New College case, which is in the core bundle.
Which you don't have.
Tab 6.
I'll read it over. I'll share it with my lord.
You've already seen the paragraph, so I think we can. It's paragraph 29 is the key paragraph.
In Lord Sumption.
In Lord Sumption's judgment.
Yep. Thank you very much.
So once he's identified the source of the power as an ancillary and incidental administrative power, he then goes on to say at paragraph 29 that the ability to use that power is not unlimited. That's what he says about halfway down, I think it's just below C, on paragraph 29. The Secretary of State cannot adopt measures for identifying suitable sponsors which are inconsistent with the Act. And for the reasons that we've developed, it's clear that not documenting, providing a digital means of documentation of those who are on Section 3C runs inconsistently with that Act, and also in wrongly exposing those individuals to the hostile environment, to those measures as well. It says that it cannot adopt measures which are coercive. This is not a coercive measure. It would assist both individuals, third parties, and indeed the Secretary of State in properly ensuring immigration control is and restrictions are placed on those that are intended to be placed upon who are here illegally, or would infringe the legal rights of others, including their rights under the Convention. And obviously for that reason we say that that clearly isn't a problem here. And then this, or which are irrational or unfair or otherwise conflict with the general constraints on administrative action imposed by public law. So it was fully recognised by the Supreme Court that when the Secretary of State uses these powers described as ancillary administrative powers, it is subject to ordinary principles of law, public law, including it must not be irrational. And so although it's correct and obviously accepted throughout that there wasn't an express statutory power that we were concerned with here, that judgment makes clear. That judgment makes clear that the exercise of the discretion by the Secretary of State when using those powers is constrained by ordinary principles of administrative law and the principle that was applied here of irrationality. So it is not a decisive fact, which I think was of the concern of my lady in granting permission, because the Supreme Court have already made plain that the exercise of that power must be in accordance with legal principle.
Would you accept, though, that there's possibly a difference between the Secretary of State establishing an extra statutory system about sponsorship, which is also outside the immigration rules? In other words, a system of rules. There's a slight difference possibly between that and practical measures of the kind we're concerned with here.
Well, my lady, I wouldn't describe the documentation of your legal immigration status and your entitlement to a practical measure. It goes back to what role does documentation of lawful status play in this system, and it's at the heart of it.
Failure to provide it deprives you of the rights
Exactly.
and entitlements. That's your case.
That's the Scottish Minister case. Yes. So it isn't about a practicality. It's about how this system is going to operate lawfully.
Well, with respect, it is, because just if one accepts that the purpose of Section 3C is to preserve a person on Section 3C leaves legal rights, what we're talking about here is not a legal measure, because everyone accepts that. Well, I mean, there may be differences about the precise purpose of Section 3C, but if one assumes that you're right and the purpose of Section 3C
Well, it's
is
assumed
to
that the judge
preserve.
is right.
Well, all right, but I mean, it's your submission as well.
Yes.
The purpose of the fundamental purpose of Section 3C leave is to preserve people's legal rights.
Yeah.
I would suggest that this case is about practical measures to make those rights effective, which is similar to the language the judge used, rather than the sort of scheme that was at issue in the New College case.
Well, in a sense, whether you describe it as a practical measure, it's a measure or not. The nature of the measure is intrinsic and essential to the lawful operation of the scheme, because as we've seen, that if you don't provide a means of digital proof of your lawful status, then a significant number or substantial number of people will be wrongly treated as if they have no legal status and will be denied legal rights that they have. So in that sense, it's much more fundamental and important than the scheme that was in play in respect of sponsorship, because this does obviously go to the very heart of the operation of the scheme. And so in some respects, it's got to be implicit within it. If you set up a scheme to provide people to have continuing, as it says, continued lawful rights, continuation of your original status, and your entitlements to benefits in a system that then requires proof in order to access those things, then it's got to be recognised to be of such a fundamental element of the whole scheme. So, but ultimately, its classification is as a practical step, doesn't, in my respectful submission, undermine or present a basis upon which Lord Sumption's analysis in paragraph 29, that when that is exercised and those practical steps are taken, you mustn't do it in a way that's inconsistent with the statutory provisions and their purpose, and you mustn't do it in a way that is irrational. So there's no jurisdictional theoretical difficulty with the foundation of the judge's approach to the fact that this was a New College basis, powers that are necessary to give effect to the immigration scheme. And as I've said, it's difficult to think of a more significant practical step to give effect to the scheme than the means by which you identify whether you're in the category of lawful migrant or here irregularly and not able to access lawfully any of these rights and benefits that are central to normal life.
Can we, if I may, can we link my lady's point with the point my Lord started out on this morning, and try to pinpoint the point at which, or what it was that caused this, on your case and the judge's finding, to become irrational? At what point did the factors change? I'm using the phrase the judge uses at 214, is it? What, 213, 214?
Yeah, 213 is
213,
where the judge
14.
identified it.
What he says is there's no inconsistency or illogical in there being Wednesbury unreasonableness now but not in the past,
Yeah.
because the unreasonableness relates to the performance by the Secretary of State of the powers and functions that are ancillary to his express powers under the Act.
Yeah.
And the factors which determine whether those functions are being performed rationally may vary from time to time as circumstances change. So we are looking, as Milady says, at the practicalities. What was it and when was it that the practicalities changed so as to make the Secretary of State's actions or omissions Wednesbury unreasonable / irrational? What changed and when?
It's the point at which a solution to the problem was available, and that the adoption of that solution was one that could be readily taken by the Secretary of
So
State.
the problem in that answer means what precisely?
The problem is that individuals on 3C leave do not have a means, documentary or digital, to demonstrate their current lawful status.
Okay, so that was a problem which was
Long-standing.
it was inherent in the hostile environment, the architecture of the hostile environment from the word go. Was
Yes.
it? So the problem doesn't change. What changes, a means emerges to address it.
Yes, and exactly. On the judge's analysis, once the Secretary of State had solved the problem for a category of people, which is the 25 categories, then he concludes that it's irrational not to do it for others because of the combination of A, the nature of this and the extent of the severity of the hardship, the disadvantages of not doing it because it's already been done, so they're minimal. The statutory purpose, if you don't do it, you're obviously undermining the statutory purpose of ensuring that those with 3C leave have lawful status on the same terms that they previously had it, and that they are not subject to these hostile environment measures that they're not supposed to be subject to, because Parliament only intends those who are here illegally without lawful rights to be put into a hostile situation which is geared to make them leave.
So having devised the technology having developed to the stage where this scheme could be introduced, it was irrational. Is this your case?
Yes, that's the finding of the judge.
Findings of the judge and ergo your case, or
Yes, yeah.
other way around.
Me first, then the judge now.
And now you. Okay, so the judge is a sandwich in your submissions, as it were. But
he is the meat.
So
Let's be said about that.
okay. I'm just sorry. Now I distracted myself from the important point.
Sorry.
So the point is that it became irrational. It was irrational of him, once the means became available, the Secretary of State, not to include sections 3C people within the category of people to whom this was immediately made available.
All of those within the 3C leave, because
All
he's
of
done
them.
it for some.
No,
So
no,
he's extended
as we established
slightly.
in answer to my questions, it's clear it was available to those who already were within the tent
Yeah,
before they applied, but didn't apply to those who were outside the tent before they
yes,
applied.
yeah. And
That's the irrationality.
yeah, that is the irrationality that he found, and ultimately, it's not a point against us that I was being questioned yesterday. Is this just about timing? Because if it is about timing, you can do it. You've already done it. You've got the means to do it. You're intending to do it in December, whether you achieve it or not, but you are intending to do it. Then when one is asking that question about the nature of the steps that need to be taken to resolve the problem, which he thinks is significant and grave enough to require to be resolved, then it's an easy step. The judge is right. It's a straightforward step. It's straightforward.
Why then isn't this the sort of administrative action which comes within the SC category, the category identified by Lord Reed, quoting Lord Bridge from an earlier case, with which the court should not interfere, because it's the sort of administrative action, and the court should not interfere unless it's whatever the phrase Lord Bridge uses.
Absurd.
It's absurd.
Because in that context, the regulations that were in issue had been given parliamentary approval. So both houses of Parliament had to approve the measure. So so there was a separation of powers issue. That doesn't arise in the context of this power, which has had no parliamentary approval. It is in the area of the Secretary of State's policy or practice, and it therefore doesn't involve the problems that the judge was fully alive to, that he shouldn't step into the fray if Parliament had already decided it, and he should give deference to the Secretary of State. He was fully aware of that. He makes reference to those principles in his judgment. But here, what the Secretary of State was doing had no parliamentary consideration, precisely because it was being done through the new college powers. So, as we've seen, our submission on the 2007 Act is that there was in place a potential statutory power, but the Secretary of State has chosen to do it through this route. But once it's done through this route, then that obviously significant factor about identifying the court's function by reference to Parliament does not arise. It's in the category of policy. Obviously, if it yeah.
Okay, well,
You
made the point.
Yeah. I can just say, sorry, this might be a helpful note from a learned friend, which is the date. And I thought we might not have the date, but what we have from Mr. Wright's witness statement 1, page 13, is that it's since the 26th of January 2023.
Yes.
That's the date that's been given in the evidence.
What? Sorry, what? That's the date
That they've extended the scheme to those on 3C leave. So it was possible before that to have a digital document if you had leave to enter. It's so I think that is 2021, but the specific situation relating to those on Section 3C leave is from 26th of January 2023.
Mr. Wright's statement is fairly silent about the details of the scheme,
Yes.
but he does append to his statement the various publications from the Secretary of State,
Yes.
which we don't have. So that was part of the material before the judge, wasn't it?
Yes.
For my part, I think it would be quite useful if we had not all of the exhibits, but the ones that focus on the scheme.
Yes, my lord, but of course,
Bearing in mind what I've already said about evidence.
that we're not going, and bearing in mind,
Yeah, I know, consistency, I know.
whatever is going to be said, the submission below on the scheme, as I'm going to repeat it, so I apologise. No evidence before me and no submissions were made on behalf of the Secretary of State to the effect that there are reasons of impracticability or expense as to why the Secretary of State would not be able to provide those on Section 3C leave with digital proof.
Forgive me for the inconsistency, but I
Yes.
think it would be quite useful to have the attachments to his statement which relate to the scheme.
Yes, of course.
Just to
And if
assure
there's anything
ourselves
that arises from it, I can certainly say that as far as the new plan for immigration was concerned, what it said, I'm recalling it, is that being able to establish your legal status is at the heart of the system.
Well, let's
see.
let us ask to have those materials. You'll have to trust us if there is anything in them
You would raise, yeah.
that is unexpected
Yeah.
and central. We intend to place weight on. We'll give you the opportunity to make observations about them.
And
So let's just identify what they are.
Sorry, I should have done that.
No, it's the material essentially in para 3 is really about the.
On the second step.
Well, I'm not sure actually.
whatever they say about the overall plan or scheme, they did not say that it wasn't impracticable or too costly to do what.
No, we've got.
Isn't it para 13 of the first statement where he talks about the long-term vision?
Yes, it's the long-term vision.
New plan for
New plan.
2021.
Yes.
So maybe JW13,
Probably.
JW14. The first reference to e-visas in regulation, so put before Parliament,
Was not until
the 2025 regulations that
Yeah.
we've been looking at.
Yeah. So I think that shows you that
That's your the SC point.
it was possible, but the Secretary of State chose not to do so. It chose to use these powers. And obviously that does draw out something that is not contrary to our submissions, the form in which the Secretary of State has chosen to extend access to digital documents to those on 3C leave up at the point of the judgment. And there's no need to be concerned about separation of powers or usurping Parliament. What I was intending to do very briefly, and then before I deal with the other points, is just to make my submissions on Pantellerisco and Salvato very quickly.
Okay, you've got to deal with section 55.
Yes, I have. But I think it's important to just make.
No, you,
reference.
as long as you know what time you've got available to you, you can use it as you like, but
Thank you.
don't lose sight of it.
I won't. So supplementary authorities 27 is Pantellerisco,
Sorry.
and it's just one. So that is tab 27.
I'm so sorry. There may be a confusion here. I came into this case yesterday thinking that there was a 2-day estimate, and thinking that was rather generous. Yesterday, I understood counsel to be telling us that it was a 1.5-day estimate, and that you were aiming to finish the case by 12:30. Or to be aiming to finish the case, therefore, by 1 o'clock, giving you some time for a reply. I'm comfortable with that. If you are, but it might just be useful. I don't want anyone to be at a disadvantage. If you thought it was a 1.5-day estimate, that's what you would. Yes.
I think we've always thought it was. Yes.
We don't. Well,
Law's looking at me because I just prompted him to think I think it is a 2-day time estimate.
Okay.
Well, it'll be
have-
clear from my lady's order, won't it?
I think it was one. I think it was one.
Well, look, I think let's deal with it this way. Everyone's working to a 1.5-day estimate. I think it's realistic. Yes, in fact, my lady seems to have said 1 day. But you. Anyway,
I usually have a caveat that says if the parties disagree, they can.
Anyway, look, let's not spend a lot of time on this.
Yeah.
Let's work to 1.5 days.
Yeah.
We will, if necessary, we'll run a little way into the lunch adjournment.
Thank you.
But
Very grateful.
I think you do need to be economical in the
I will
remaining
do.
submissions.
My learned friend indicates to me that he needs 20 minutes, so I'll
Right.
take that into account. And
See if you can finish in 20 minutes, and then we won't have to run into the lunch interval. But let's see how we go.
So looking at Pantellerisco,
yep.
we're at 27, begins at 8:05, and what I just want to emphasise was what was not really addressed yesterday is at the heart of why it was that this court overturned the judgment of Mr Justice Cavanagh, and is ultimately at paragraph 79. But it may just be helpful just to have a look at 78, because that deals with the issue of what's the sort of threshold for when any hardship.
Well,
would
just
be
if you're short
there.
of time, let's just read. So 78 and 79, yeah.
Yeah, I'm emphasising in 78 substantial and serious.
Okay. Yes.
And so we say that approach, substantial and serious fault, is exactly what the judge found here in our case. But what is different in Pantellerisco from Johnson, and we respectfully submit our case, is that the court concluded that the departure from the actual receipts principle would seriously impair the workability and reliability of the assessment.
Yes. What was Mr. Mallet relying on Pantellerisco?
He referred to it.
I don't seem to remember. I don't have any notes of our being taken to it.
He did take you to it.
Did he? I'm so sorry. He read another passage. You're quite right.
He mispronounced it.
Yes,
And
that's
Lord
right.
corrected
Okay.
him.
Yes, it's come back to me now. It's another passage. That's why I did.
Yeah.
Yes, I see. Thank you. That's why you want to refer us to this passage.
That's why I want to show you
Yeah,
that.
thank you.
So for the two purposes: one, what's the threshold of harm or disadvantage? And two, the critical important point here is that in order to make the change that was identified as necessary would make the system unworkable and unreliable. And at 80, the court went on to identify further that it would involve, this is about 5 lines down, a derogation from a general principle of the legislation.
Yep.
And so that's ultimately the reason why the court concluded a different approach to Johnson, and also for that reason rejected reliance on Johnson, saying that it was only superficially similar. As we know in Johnson, the change would have furthered the purpose of the legislative scheme, whereas it's clear in this context, in this case, that what was being proposed, even if it would have alleviated some hardship, it was unworkable in practice and ran counter to a fundamental principle in the scheme.
Point. We have the point. You've really made it.
And that's actually also similar in the Salvato case, which is at 28. And that concerned proof of payment in order to access child benefits, which also caused some difficulty for individuals. You'll see that at 116. But ultimately, the court's conclusion was that, as you just skipping to the key paragraph at 126 on page 869, it wasn't about fine-tuning to cater for an arbitrary harmful impact of the type identified in Johnson. As in Pantellerisco, it seeks to stigmatise as unlawful one of the elements of the system which was deliberately chosen and which potentially gave rise to hardship for those who are unable to comply with the requirements and found it difficult to do so. And again, saying that there was a rational justification for the decision that had been taken about how you prove your entitlement to the benefit, which ran contrary to the scheme that Parliament had identified. So again, whilst both of those cases are addressed by the judge below, and are examples of this court using the framework of Johnson to test the lawfulness and rationality of the decision, it's obviously key to ensure that what is being proposed does not run counter to the objects and purpose of the legislation and does not result in unworkability or impracticability in implementation. And for the reasons that I've developed, I know at some length, the findings of this judge, which are not susceptible to being overturned on appeal, clearly show and establish that documenting or access to the digital document to confirm lawful status is at the heart of this system.
Well, we do have that
and
point, Ms
it
Harrison.
is also necessary, it wouldn't run counter to the system to actually facilitate that. So that's why we say that line of important case law from this court, it was properly identified by the judge and properly applied on the facts. And on that basis, we say there isn't a proper basis at all for the court to overturn the judgment, as my learned friend says, on irrationality. And I'd invite you to endorse his judgment. The alternative way in which we put our case, so I'm moving on to the cross appeal, which is the Padfield case. And in some respects, I've already addressed that proposition, because ultimately what the judge concluded was that applying the Padfield principle, which is obviously not in dispute, that rests upon being able to identify and express provision.
Well, surely your case on Padfield is simply that there's been a big difference in you and Mr Malik, which you've already made submissions about what the purpose of the legislation is.
Yes.
If you're right, a Padfield is a perfectly appropriate tool, you would say. If he's right, it isn't. But it all depends on what you say the central purpose of the legislation is. Is it as simple as that, or have I missed something?
I think that on the that's not the reason the judge. That may how it turns out, that the ultimate reason was because of the source of the power to address it. So because it comes from the ancillary incidental powers and isn't about the Secretary of State failing to
I see.
To make or has made a decision or is not making a decision that's contrary to an express statutory provision.
Yeah.
Therefore, that's not a Padfield case. So
yes, sorry, you're quite right.
That's,
so what's your answer? What's your answer to that?
My answer to that is the paragraph 29 of New College, that the court made it clear, Lord Sumption's judgment, that that you mustn't exercise these ancillary powers inconsistently with the statutory scheme. So to that extent, there's my respectful submission.
Yes,
there's no difficulty, and
no,
so that's our proposition on that, and
very clear and succinct.
And then turning to the second round of appeal of my learned friends, which relates to the judge's ruling on section 55. Let me just get my notes. I'll be quicker. Sorry. So the judge dealt with this issue. If we turn up the full bundle. At 162 to 165. Sorry, that should be page, paragraph 243. He set out the statutory provision in section 55. And I know it's familiar, but essentially it's the Secretary of State must make arrangements for ensuring the functions mentioned in subsection 2 are discharged, having regard to the need to safeguard and promote the welfare of children who are in the United Kingdom. And 2, if we go to 2A, definition of function is any function of the Secretary of State in relation to immigration, asylum or nationality. It makes reference then to the guidance. Obviously, the key part of the guidance was to make reference in paragraph 2.7 to core principles, central to which was principle 2, the reference to the UN Convention on the Rights of the Child and the best interests of the child being the primary consideration. That was obviously in circumstances where previously the UN Convention was an unincorporated international treaty. So that was what was seen to be significant about Section 55 in the earlier 2007 guidance. we were domesticating to the extent that there had to be due regard to the best interests of the child into our legislation. And your lordship was right yesterday in observing that I think the most recent, or one of the most recent expositions of what this duty covers is set out in detail at 246. For your lordship's note, it's in Core Authorities 10, page 260, but we'll take it from here if that's easier. And you'll see at paragraph 69 that it had been considered in ZH Tanzania, and there was no dispute about the propositions, and that includes at 1, it was enacted to give effect into domestic law, the UK's international obligations.
It's probably quicker if we just read through this.
Yes, that's probably easier if you just read to the end.
I'm reading right to the end of 5. Yes, but that's very familiar stuff. Yep.
And you'll see that what was recorded at 248 was the change of position of the Secretary of State at the hearing. So the Secretary of State had previously said in pleadings and in the skeleton argument, I think, that when the mechanisms used to provide documentation were not a function, because that was reflected the prior position that the Secretary of State was taking, that he had no power. So there was no power and no function was in play, and in part obviously because Section 3C had automatic effect, so therefore what was being suggested was that no function was involved. But that was...
I think the point was a slightly different point, which was that Section 3C leave arises as a matter of law. So when Section 3C leave arises, the Secretary of State isn't exercising a function.
Yes,
now,
they were yes, you're right.
So, I mean, it is a slightly different point.
Slightly different point, but I think they were interrelated in the way in which the whole case was initially approached. But your ladyship is right. It's saying because it's by dint of statute, then there's no function that the Secretary of State exercises, but that wasn't the position that Mr Malik took properly, we respectfully submit, before the judge. But that is of importance, because if you then go on to see what the judge did conclude at paragraph 249, that the question in the case about whether or not to provide digital proof of 3C status was a function of the Secretary of State. That's at 249. And then his critical reasoning is at 250, and probably again it's easy for the court to read it rather than read it out.
Yeah, but it's simply a very narrow, I don't mean this pejoratively again, it's a very narrow procedural point. Since the Secretary of State didn't believe he was exercising any functions to which Section 55 applied, he can't have considered it.
Yes, and obviously, yes, and there was no evidence that he had.
Well, yes, all right.
Because it may be that it arose from that, but it might have been, you could say, well, we did consider it, but Mr Wright didn't say that it had been nevertheless considered. And I gave you that reference in when the judge was reciting the facts about how if the parent is not able to work, as has happened to Ms Adjei, she didn't have income for several weeks. She was therefore without money. She was go to a food bank. She was dependent on charity. This is a family that lives on the breadline. then inevitably that's going to have impact on dependent children if the parent's income is impacted. That would obviously also be the case if they're wrongly denied benefits, as there was evidence about. And so the position of dependent children, often British children, because that's what gives the individuals the right to remain in the country, they are being adversely affected by the inability of the parent to.
Doesn't make a difference if they're
demonstrate
British. It doesn't make a difference that they're British children, doesn't it? Does it?
No, children. They're going to be children that have. Ms Adjei has both a British child and a child with.
Yes, but sorry, you were saying as if it was important that the children were British rather than non-British. But the duty section 55 doesn't apply only to British children.
It doesn't. But only in the sense that not only are migrant children or children with limited leave to be here adversely affected by this provision, but also those who are British are affected too. So that's the only point that I make. But ultimately, as your lordship observes, their status is not what's important. It's that they're going to be wrongly, adversely affected by the fact that their parents' income is interrupted or their dependence on public funds for subsistence is going to be interrupted. And so there is a clear need to consider the position of children and the due regard duty to safeguard and promote their welfare, but that hadn't been done. And in some respects, it is illustrative of the weaknesses and inadequacies in the Secretary of State's overall response to the case, which we have discussed, that the Secretary of State's witness did not identify the risks of being wrongly treated as unlawful in the UK, saw no prejudice and saw no disadvantage. So that was not. So therefore, the judge was entirely correct to say that that duty hadn't been properly addressed, and the only answer that my learned friend offers is a very surprising proposition that the Secretary of State has discharged the duty simply by issuing the guidance. So obviously, if the guidance hasn't been applied either to an individual case or to a policy or to a general rule, then that's plainly unlawful. The fact that the policy is issued can't possibly discharge the duty. It has to be applied. And it clearly wasn't here, and the judge was properly entitled to make that additional finding. Obviously, in that respect, the duty on the Secretary of State was to go away and to have due regard and to exercise that duty. That obviously has also been stayed as a result of the judgment, and as far as we know, that hasn't been done yet either. But that's one of the things that the Secretary of State would need to do.
Is there anything in the compliant environment EIA that deals with the position of children? I mean, you may not be able to answer that.
I think I can say that nothing does, because nothing does address this issue in respect of the compliant environment at all. But we can provide you with that. There was nothing. It had a very limited focus about whether or not there was discrimination depending on age, and it thought that older children were going to be more affected, or age would have a factor. So those over 18 were more likely to be adversely affected because they were going to be seeking employment, etc. So it thought children wouldn't be affected in a discriminatory way by the hostile environment measure. It didn't think about and didn't address what could be the consequential adverse effects of parents being wrongly treated as illegal and denied access to the elements that constitute a normal
adverse
life.
Effects on children completely parasitic on the effects on parents?
Well, as part of because they're part of the family unit, yes. But I suppose that they exist. They are also. I think that they obviously rest upon.
If you can't keep your job or you can't keep your home,
That's going to have an impact
That will
on
have
the
an
child.
effect on the adult, but is there a discernibly different effect on the children?
Well, there's an equal effect. Perhaps children are more adversely affected by lack of funds or being homeless, but
Well,
the
all right.
impact is similar.
Yes,
But it could be worse for children
Right.
because they're more vulnerable by definition.
All right, thank you.
Yes.
So I think those are my substantive submissions. The question is, how should I provide you with the references to the Secretary of State's position as to there first being no power.
Well, I had a
to
quick
do
look
this.
at the detailed grounds and I couldn't see any assertion by the Secretary of State that there's no power to do any of this.
Nor could I.
There
Nor
was.
could
I think the easiest way, rather than take the time now, is if you would permit, because there's a number of references, right? That'll take a little bit of time to provide them. We could provide them to you by 2 o'clock, so that you've got them in writing.
Well, all right. If you do that, will you send them also to Mr. Malik? You
Oh, yes,
take
of
the
course.
risk that Mr. Malik may say that's not what it says at all. But at least we'll see what you're relying on.
How many are there?
There are. I've got 4 notes.
Well, it's quite an important point. I think
Yeah. Maybe
if
I
my
can
lord
do
and
that
my
while I'm
lady-
sitting
if my
down.
lord and my lady agree. I think let's hear Mr. Malik on everything else. By that.
I'll be able to have
By that time you'll be able to sort it out. Then you can give us that, and we'll give Mr. Malik a chance to respond.
Sure.
Yes, Mr. Malik.
Lady Milords, just 5 very short points on ground 1 and cross appeal. Lord, I completely recognise what you just said about providing notes over lunch about the defence.
Well, I think what I meant to say just now, maybe it didn't quite get through, is that we will deal with it before lunch.
Yes. Yes. Can I say this? And I'm sure there is some misunderstanding.
Yes.
I did not plead that the Secretary of State had no power to issue e-visas to those who are on Section 3C. It would have been the most extraordinary defence
Right.
to plead.
Right.
In the circumstances where I was relying on Jonathan Wright's evidence stating that the Secretary of State has been issuing e-visas to those who are on Section 3C. So
Right.
pleading that would have meant that I was essentially arguing that the Secretary of State was doing something.
Up to Tavares.
Yeah.
So you have detailed grounds of defence at page 2 to 5 onwards. I did not plead that point. I could not have sensibly pleaded that defence.
No. Okay. Well, as you see, I was surprised when Miss Harrison said that would be your position below, and I, like my lady,
Yes.
surreptitiously had a quick look at your grounds of defence and couldn't see it. So that's why we'll find out shortly what she says has that effect, and then it'll become clear whether it's a good point or
I'm very grateful. And just for your note, paragraph 107 of the judge's judgment, where the judge says that it's common ground, it's not.
Yes, it's common ground. There's
Yes,
a power.
there is a path. Yes. So that wasn't a defence.
yes. Although yes, exactly. That also seems to me to be a red herring, because I mean, even she was saying that it was common ground at the hearing. The point was whether it had ceased to be, whether it had not been common ground until the hearing, which is what she was saying. Yeah. Okay.
I mean, the judge asked a question as to what is the source of the part
Yes.
at the hearing,
Yes.
and I said it's New London College, and I sent an email afterwards. If you just for the purpose of your note, that email is in the supplementary appeal bundle, page 2 of 5.
I've seen.
I
Yes.
essentially said that the source of the part, as I said, is New London College. Here is the copy of the judgment.
Yeah.
So that is the first point. The second point, my lord, is what Miller and friend said about the role of this court in hearing appeal from the judge's decision. Well, the question before the court is a question of law. You can only have one right answer: whether there is a public law obligation of the Secretary of State to do X. If the court concludes that there is no public law obligation, the court will inevitably conclude that the judge was wrong in law.
Yeah.
So we're not in proportionality territory at all. The third point concerns a question that Lady Justice Elisabeth Laing asked when Millennium Friend was making submissions yesterday. Milady asked whether rules referred to in section 1.4 of the 1971 Act are the rules that are also referred to in section 3.2 of that Act.
Yeah.
The answer is yes. And if an authority is needed for that purpose, it's the judgment of the Supreme Court in Alvi.
Yes, I thought you were going to say that.
It's behind tab 21 of the authorities bundle. It's paragraph 7 of that judgment that is right on that point. My fourth point concerns what Millennium Friend said about the purpose of section 3C. Now, my submission on that is not a novel submission. All I ask Milady and Milords to do is to simply endorse and adopt what this court had said in Akiniola. In that judgment, paragraph 40 and paragraph 42, this court said that the purpose of section 3C is A, to prevent people from becoming overstayers, and B, to prevent people from making successive applications leading to indefinite extension of their stay. That is it. And that then, submission brings in a range of incidental benefits.
Yes.
Namely, a person qualifies for indefinite leave to remain after 10 years. If a person is working, that person is allowed to work. But it is not the purpose of section 3C to allow people to work in the country as such. But there is, in my respectful submission, a logical difficulty with the submission that Millennium Friend makes about the purpose of section 3C and what the judge has said. Now, when you're seeking to ascertain purpose of section 3C or the Immigration Act 1971, you will obviously focus on the act, the primary legislation. The purpose cannot possibly change over time. In answer to a question by my lord, the Vice President Millennium Friend said that, well, things became unlawful in 2021. Well, that must mean that the Secretary of State was acting consistently with the purpose of section 3C since its enactment up until 2021. But then started acting inconsistently with that purpose afterwards. That, with respect, cannot be right. I mean, that may be a good point to make on Wednesbury, but not, in my respective submission, a good point when it comes to the purpose of section 3C or Padfield.
Yep.
My final point, the fifth point, my lords, my lady, concerns what Millennium Friend said about paragraph 210 of the judge's judgment.
Yes.
This is where the judge said that the Secretary of State has adduced no evidence as to why she would not be able to provide digital status to everyone who is on section 3C. And Millennium Friend relies on that heavily. Now, there are two answers to that submission. The first answer, my lords, my lady, is that under the statute, under the primary legislation, the Secretary of State is charged by Parliament to regulate immigration control. She is politically accountable to Parliament for her actions and legally accountable to the courts. In my respectful submission, it is not for the Secretary of State, and I say this with respect and diffidence, it is not for the Secretary of State to explain why she is not taking a particular step to a court unless we are in justification / discrimination territory, or unless a claimant establishes that there is a public law obligation on the Secretary of State to take that step.
Hang on. Sorry. Yep.
Take. I mean, one example to test the point would be to contemplate a claim where a claimant comes to court saying that, well, the Secretary of State should grant amnesty to everyone who is living in the country unlawfully, because A, those who are living unlawfully face real hardship, and B, because the Secretary of State has the power to grant an amnesty and she has done it in the past. In my respective submission, this court would be changing the fundamental nature of judicial review to place an obligation on the Secretary of State to come to court to explain why she is not taking that particular step to grant an amnesty to everyone. Unless, of course, there is a discrimination argument where the Secretary of State is providing a justification, or where the claimant establishes that there is some other public law Padfield type of.
Well, we're into deep waters here, but the only other example I can think of straight away where the government was held to have been acting unlawfully because they did something for which an explanation was required and didn't give it,
Yes.
and that is Miller 2, where I think that is the ratio. I
Yes.
haven't looked at it recently, that there will be circumstances where not because of any public law duty to give an explanation, but where your action or inaction is of such a character that it will be unlawful unless explained.
Yes.
That makes it less constitutionally.
Yes.
And that's really an evidential matter, isn't it? What's being said here is it's quite close to discrimination, though it's not framed as a discrimination argument. Look, you've already started to do this,
Yes.
but you haven't done it for everybody. That's bizarre. Why haven't you done it for everybody? It must be irrational, unless there is a reason, in which case please tell us what it is. Is that unacceptable? Does that breach your principle which you've just adumbrated?
In my respective submission, yes.
Right.
Yes. I mean, if the Secretary of State has done X for a particular category, in my submission, she's not obliged to explain to the court why she is not doing X in another category. Unless, of course, we are in justification, discrimination.
Yes. No. Well, I see that. Your point's well taken. But I'm just testing whether there isn't a halfway house where the circumstances are such as to call for explanation, or because what you have done appears plainly irrational. Anyway, and you take a principled line on that. No.
And of course, this case is far apart from Miller 2.
Yeah, right.
For
Yes.
obvious reasons.
I don't. I think I promise you, if we're going to decide this case on Miller 2, we will give the parties operating to the opportunity to make.
So that
I was just throwing that out there. Anyway, there we are.
Okay.
Yep.
So that's the first answer to my Miller
Yes.
lines on paragraph 210. The second answer is that I'll invite the court to look at paragraph 13 of Jonathan Wright's first witness statement.
Yes, just give me one moment.
Page 5, supplementary manual.
Yes, thank you.
I mean, I'm not inviting the court to look at. I mean, you have looked at that paragraph already.
We have.
And this morning. So, Jonathan Wright is saying that, well, this is the Secretary of State's long-term vision. We want to do this in this way, gradually, sequentially.
Well, where does it say that?
Well, yes, he says that.
Where does it say gradually?
I think I picked that word from another piece of evidence, I think. My apologies.
Or for that matter, sequentially.
Well, isn't that implicit in the bit that follows? This means that from 26th of January 2023, where a person has an existing e-visa and has submitted in time,
Yes. So
they can provide the.
yeah. So that is yes. So this is of course implicit in my respective submission. When the appeal was brought to this court, in the appellant's notice, there was another statement by the Secretary of State, essentially in support of the stay application.
Yes.
Where the point was made sort of more clearly that the Secretary of State wanted.
That wasn't evidence before the judge.
And then there's the last sentence. As the changes to digital status of Section 3C extensions cannot be retrospectively applied to all those who are current in time.
And then the last sentence that Milady has just read.
So sorry, I was just making a note. Which passage?
So it's the last sentence of paragraph 13.
On page 6.
On page 6.
Yeah, read with the sentence that begins just a couple of lines below the bit that's underlined. This means that from 26th of January 2023, where a person has an existing e-visa.
Yes, so he's making 2 points. That the first is that the Secretary of State is doing this from one route to another route in a sequential manner. The second point he's making is in the last sentence that, well, we cannot provide e-visas to that group. And as I
Yes,
said,
but surely that's. Am I not right? There are two points being made, or perhaps not being made. But there are 2 points which you would like to be made. One, that this process is being done in stages.
yes,
For different categories of visa applicants.
yes,
2, and this is a separate point, that if you've already made an application
yes,
by the old system, you can't be granted an online status verification. They're not the same point. Because there will be some groups who, even as at today, as at the date of this statement, aren't even being offered the opportunity to make online e-visa applications.
Yes.
So, although I see the force of your second point, we'll need to think about it a bit more. It's not really the point we're on now, is it?
no, the judges.
It might, for example, it might not help Ms Adjei, but I can't remember what Ms Adjei's particular facts were, but anyone who has already made an application at the time of the judgment or the time of the claim, strictly speaking, can't be helped. But that doesn't meet the more general point.
No. So the judge is saying that the Secretary of State has not provided evidence as to why she would not be able to just provide digital status to everyone right away. And in my answer was twofold. The first was the principal point. The second is that the Secretary of State has said that I'm doing it in this way, and I cannot just provide digital status to everyone. So on the point, my lord, that you made, if you look at Jonathan Wright's second witness statement,
Yes,
paragraph 4, he sets out the routes where
Yes.
e-visas were on offer. And if you, Lord, just keep that in mind and then look at page 205 of the same bundle. Uh, 205.
Yeah.
So this is an email that I sent to the judge after the hearing.
Yeah.
Just providing essentially further clarification as to that, and you'll see that there are 89 categories, and you'll see the categories that were offered e-visa options at the time, and the categories where...
The judge clearly understood,
Yes.
because he refers to it himself, I'm not quite sure where he gets it from, that this was a rolling process, because he says it's not complete now, it's only available in 25% of cases, 25% of categories,
Yes.
but it'll all be finished by 2004. Where did he get that from? Was that just what he was told that in submissions? That I don't see that in any of the witness statements unless I've missed it.
Yeah, I think it was in submissions. I was looking for that. I think it was made in submissions.
Yes, so that was the intention. Yes.
So it'd be quite useful to know what he was told, because it may well be, I don't want to put words into anyone's mouth, but it is at least clear that he knew that this process was happening in stages. So in that sense, he knew, and obviously nobody contested it because he made a finding to that effect, that it was being done, if you like, gradually and sequentially. That is, even if it's only 2 stages, it's gradual. Gradual means step by step,
Yes.
and sequential because one's after the other.
Yeah.
So he knew it was being done gradually and sequentially.
Yes.
What he didn't have was evidence as to why it wasn't being done all in one piece. But I don't think that you could have delivered orally.
No,
He
no,
certainly doesn't
it's
suggest he
really
did.
paragraph 13 and
Or it didn't make
First.
any submissions on it either.
yeah.
And perhaps also there may be something in the documents appended at JW 13 and 14,
Yes.
which would
Yes.
elucidate the program of digitisation.
I mean, perhaps I can just try this out on you. This is very common in this court and can't be helped, but the case, the focus of the case was rather different below.
Yeah.
The point on which you lost was always made by the claimant,
Yes.
but it was not the only point.
Of course. It was.
And as Ms Harrison's very frankly accepted, it was an important part of her case that, in a sense, e-visas were that you didn't have to do this by e-visas. You could have done it by issuing a physical document. The judge explained why that didn't work, and she now doesn't pursue that. But that was an important part of the case below. I'm not sure where that gets us, but it's sometimes the case that lacunae in the evidence or submissions reflect the slightly, what appear to us to be lacunae in the evidence or submissions, reflect the way in which the case went. But I'm not sure whether that's a really satisfactory explanation here, because the e-visas were always part of the picture. Anyway, I just throw that out in case you, or I suppose Ms Harrison, want to make any observations about that.
Yes. Well, yes. You have the pleadings, and Malord.
We can see what the case was.
No, Malord is absolutely right with respect. I mean, I saw the case when I got involved as primarily a case about sort of physical
Yes.
proof, a letter, and that was a sort of focus of the summary grounds of defence and detailed grounds of defence, and then of course things developed. But I completely accept that the point that is made by the respondents was made in the pleadings. It's not a new point.
Yeah.
And I'm not.
No, that's fine.
Yeah.
Don't worry. We have, I think, your answers.
Yes.
Subject my lord or my lady want to ask about them on this. As Ms Harrison rightly pointed out, crucial part of the judge's reasoning in paragraph 210 that there was no evidence as to why the digital scheme wasn't rolled out to everybody at the time when it was rolled out to the first people.
Yes, immediately, and you have my point about the principle, and secondly, paragraph 13 of the
Yes.
rights statement.
Yes, and you say you can get enough out of para 13.
Yes.
Yes, I see. Right.
So these are my 5 points on ground one.
Yes.
In cross appeal. Just very briefly on section 55. May I just take you to, if you have the core appeal bundle, page 2.
Is this the core authorities?
Appeal bundle.
Appeal bundle, yeah.
Page 240.
Yeah.
In your defence.
Yes, these are detailed grounds of defence. Just to answer the point that Elisabeth made, that the Secretary of State's position shifted, and this simply illustrates the point that Lady Justice Elisabeth Laing made when Elisabeth was making submissions. So at paragraph 42, I made a submission that extension under section 3C is automatic, and the Secretary of State is not exercising any function,
Yes.
and the duty under section 55 does not apply.
Yeah.
But that's all.
Thank you.
But then 43 to 45, I said, accepted that section 55 applies when the Secretary of State is considering or processing applications for leave to remain, relied on the policy and said that, well, that discharges the function. And if there is any illegality in one particular case, the applicant can sort of challenge the breach. Can I just ask Lords and Lady just to perhaps consider the example of amnesty again? So contemplate a claimant that brings the claim saying that, well, the Secretary of State should grant an amnesty to everyone who is living here unlawfully because it adversely affects children. Well, is there an obligation on the Secretary of State, a sort of a daily obligation on the Secretary of State to keep reviewing the policies and to decide how not taking any particular action would adversely affect the children? That, with respect, is simply unrealistic. So no breach of Section 55, therefore, in this case, and you have my point in opening, that the judge's analysis is premised on his earlier findings. So if I'm right at the round one, the appeal should succeed. I'm very grateful.
No, thank you. No. Now, Ms Harrison, you were just going to
Be the reference.
give us the references to where you say the position only became clear at the hearing. Yeah, what are they?
So the first reference that is to the detailed grounds of defence, which is in core bundle 233.
Yeah.
Paragraph 20. And the response on the Padfield principle was that section 3C.
Sorry, which paragraph did you say?
20.
Paragraph 20.
Yeah, thank
Page
you.
233 confers no discretionary powers. For your lordship's note, that was repeated in the skeleton argument, core 177, page 19. Paragraph 19, sorry. On irrationality, which is at 237 of the same bundle, in the detailed grounds at paragraph 35. This is under irrationality. No entitlement under.
Sorry. Yes, I see. 231 seems to be about policy and object. It doesn't seem to be about power.
Well, I can only show you the
Yes,
provisions.
okay. Well,
submissions.
thank you.
So
We won't argue the points with you. We can see them.
35 and on 237, and a similar submission made in the skeleton argument at 181, paragraph 34. And
35 doesn't talk about a power, does it? It talks about a duty.
yeah, it basically. Yeah, duty or discretion is what it says, and you have to then look at it in the context of what the judge said about this and how it occurred at the hearing.
Well, don't worry. Just give us the references for are those the two references in the respondents in the Secretary of State's case?
Yes, and there was no reference anywhere in any of the Secretary of State's pleadings or skeleton argument to the fact that there was a power to do what we've been suggesting through the new college route.
Okay, so your submission was that I thought that the Secretary of State's case was there wasn't a power.
That's
But now you're saying there was no reference to such a power in their case.
But the pleading, we say, was on the premise that there was no power or discretion to do what we were being proposed, and if by way of there was no reference at all to the fact that it was permissible to do it under new college. That's a negative thing.
Yes.
How it arose then in the judgment was in the course of the hearing was that was the way in which the case was advanced until this judge asked my learned friend, well, what is the source of the power for what is being done now? And only in oral submissions was that referred to. And that's why you have the note at paragraph 205 of the core
Yes,
bundle,
we've seen
which
that.
you've seen. So
Very well.
the judge wanted specific explanation because it hadn't been part of the Secretary of State's case previously.
Well,
So
thank
that's
you.
the point that we make.
Yeah, well, we've now got the references. We can
Great.
make of them what we will if it turns out to be important.
And there was one new point of law that my learned friend raised, which was the proposition that there's no duty or there's no obligation in public law for a decision maker to justify the step that he's taken. And in my respectful submission, that is a bold proposition in the context in which ultimately irrationality is about justification. We know from the formulation without the convention from the Smith case, Smith and Grady, the greater the intrusion, the greater the need for justification. That's Smith from whenever. And obviously the Johnson approach to rationality, the framework, inevitably involves looking at the disadvantages of alternative solutions. So if the Secretary of State doesn't have to do anything to explain the decision that she's taken and doesn't have to identify why there would be impracticability or cost problems, then it's difficult to see how that framework can arise.
You're luckily having a rejoinder, but we've got your point. Yeah.
Yeah. Well, I thought that was a new point, and unless
Well,
I
I'm not-
insist further, those are my.
Yes. Okay, but don't worry. I have made.
What it does confirm is what the judge found, that there was no evidence, because my learned friend said it was a duty to provide it. But that is a rejoinder, and I apologise. You couldn't resist it. I couldn't, sorry. And I'm grateful for sitting a little bit later to accommodate the case. Thank you.
Mr. Malik, I think you're entitled to a surrey joinder, but I'm not encouraging you, but I'm not going to deprive you. You can do that. Right.
Thank you.
Well, we are very grateful to Council for their careful submissions and to those behind them, invisible in the case of Mr Malik, but I'm sure there are some behind him.
Not completely invisible.
So sorry, how very rude of me. I was really
Unobservant.
Yes, I've completely messed this up. So I was really referring to the fact he has no juniors, but of course then there probably isn't an invisible junior. Anyway, let me start again. We're very grateful to all concerned for the submissions that we have had. We will be reserving our decision. Judgments will be circulated in draft in the usual way and for the limited purposes identified in the Counsel General for Wales case, with which you will both be very familiar, but they should only, the drafts should only therefore be seen by those who have an interest in seeing them for those specific purposes, and if there's any wider circulation, that may be a contempt of court. Thank you both very much.